Hello, everyone. Welcome to AI Chats on Privileged, what California's lawyers need to do now. I'm Max Goosen, president of the DHBA Barrister section, and I'm delighted to introduce our speaker, Usama Kaf. Usama is a partner in Fisher Phillips Irvine office and a certified information privacy professional. Usama co-chairs the firm's AI, data, and analytics practice group, as well as the privacy and cyber practice group. His primary areas of practice are workplace privacy and data security, employee defections, unfair competition, trade secret theft, and corporate espionage and artificial intelligence. As co-leader of the firm's consumer privacy team, Usama advises clients on compliance with state consumer privacy laws, including the California Consumer Privacy Act and the California Invasion of Privacy Act. He regularly conducts trainings and publishes articles relating to consumer and employee privacy and data security. All right, Usama, turning it over to you.
Thank you, everyone, and thank you to the Beverly Hills Bar Association for hosting this CLE. I'm Usama from Fisher Phillips, and I'm thrilled, maybe slightly terrified, to be here to talk about AI, confidentiality, and the attorney-client privilege. If you've ever worried that your client might accidentally waive privilege by CCing the wrong person, imagine what happens when they CC ChatGPT. So today's session, AI chats aren't privileged. What California lawyers need to know is not really meant to terrify you, though that may be an unavoidable side effect for which I apologize. It is really to help all of us understand how these new tools intersect with our ethical duties and how to use them safely. If you have questions at any time, please put it into the Q&A. I will do my best to monitor those questions, and I may stop and answer them live as we're talking, or towards the end when we have a little time for Q&A. The AI is everywhere. Our browsers, email, legal research tools that we're using. We, as lawyers, use it to check tone in our messages, to sometimes draft messages to clients, to internal messages, external messages, draft any kind of communication, to draft discovery responses, to summarize discovery responses, to summarize transcripts. There are now even new tools that could be used at depositions to monitor what is happening and identify inconsistencies in what the witness just talked about from a prior deposition or in the same deposition. There are a lot of other uses that are all over the legal industry, every facet, not just litigation, but transactional work as well. But when you paste part of a client email or a draft brief into an AI tool, you may have just shared it with a third party, and therein lies the issue. And that third party does not owe confidentiality and any obligation of confidentiality. The single act of sharing the information with a third party can waive privilege, expose work product, and potentially violate the rules of professional conduct. Some of the things we're going to talk about today include guidance that has already been put out by committee of the state bar, as well as by the ABA and other associations related to a lawyer's ethical duties when it comes to using AI. But I think most importantly is that we all should familiarize ourselves with the technology itself at the end of the day. Use it, test it, understand how it works, and otherwise you probably have to consult an expert on how to use it before you use it. But generally, it's a good practice for each of us as lawyers to personally use these tools to really understand what are the limitations, what are the risks, and how to not use it, and how to use it most productively. Today we are going to cover why AI interactions generally fall outside the attorney-client privilege. We're going to cover confidentiality and work product risks under California law. We'll talk about how to safeguard your practice and your bar card while still using AI productively. In other words, how to avoid being the next Mata versus Avianca headline. That's a case where a lawyer used an AI tool and resulted in coming up with some very fake citations. Now, this presentation is not about hallucinations in ChatGPT and other Gen AI tools. That's a whole nother topic that we can delve into. However, as a result of some of the cases involving AI hallucinations where lawyers have put fake citations into briefs submitted with the court, in some of those there was the potential, or commentators have made comments about how there's always the potential for disclosing information, and in some of these cases, if you dive down, it's quite possible that in coming up with some of the analysis, some of the information, some of the writing, that information was shared or disclosed with that third party that about a client. So client confidence could have been disclosed in some of these cases involving AI hallucinations. But separate issue is the lawyer's duty to make sure that you're not putting fake citations into the record. That's a whole nother reason related to building enough safeguards in the use of AI, Gen AI tools, and to ensure that those tools are used appropriately for the purpose for which they are built and tested. And there are now sophisticated Gen AI type tools that are trained specifically on actual case law that exists, and they only look within that closed environment, as opposed to just giving you what you want and giving you, the answer that you're looking for. And for example, CoCounsel is a good example of that, which can be, within a closed environment, and it's looking at only at Westlaw or whatever search tool you connect it to, so that everything is limited and it is not creating a new law, but you always have an obligation to test it. I don't want to dive down too much into that, but that's one of the safeguards you should think about as we go through the presentation. All right, and I see we are already getting some questions, which we are gonna hopefully answer on some of these topics that we'll cover. But if they're not answered, I'll certainly go back to them and start talking to them. But let's set the stage first. The first place to start is the model rules and the California equivalence. And one of the themes out there from the ABA, for example, that has published a formal opinion on this issue, is that we don't need a new rule to address use of AI by lawyers. Existing rules and existing duties and guidance is plenty sufficient to address all these issues if we really understand them and talk about them and apply them to this new technology. So there's no need for establishing new law and new rules for lawyers because the rules are already there. And what are the rules? Number one, competence. It includes technological competence, and that goes back to the the issue that I mentioned earlier, that each of us as lawyers need to have the technological understanding of the tools that we are using in the practice of law. I would draw the analogy to e-discovery tools with guidance out there, in California that says lawyers need to either know how e-discovery tools work when they use them, or they need to engage an expert who knows e-discovery and will be able to identify the right tool to use and the technological process for culling through data and identifying what is relevant and what isn't. But that's the analogy I would draw, is that same technical competence duty applies to AI. You can't just be the average user. You have to be a lawyer user, which means you got to know it. You have an actual duty to know how it works. And if you don't know how it works, then get some technical training, obtain training, and in fact, some of these tools will tell you how they work, right? Ask ChatGPT how best to use ChatGPT. Ask ChatGPT how it is built. It'll answer the questions for you, right? So you you can train you can understand how the tool you're using actually operates if you ask the right questions. But beyond that, you can obtain some specific training on that issue as well. The second is confidentiality. That's the big one. And this is where there's always a risk of uploading client information to public AI. It means you're now disclosing it to a third party. So anytime you are uploading information, you can scrub it. Once you've scrubbed it in a way that doesn't identify that potentially, but may not necessarily be the right answer every time, depending on the information that is still in the document. But that's just one way to minimize the risk. But really, one of the things that I would recommend would be engaging tools on an enterprise level, which makes it, makes sure that it is a closed system, a closed environment, where the tool is not being trained on your client's data, the model is not being trained on your client's data, and the AI developer and provider is not sharing and receiving that data and using it to train their model. And perhaps the data doesn't even leave your system, right? If it's a license to use it within your environment, then the data doesn't really leave your system in the same way that you put your discovery documents into an e-discovery relativity instance. You're not disclosing it to a third party, right? The third party may be hosting it for you and providing the infrastructure for it, but it's not a disclosure that would result in the waiver. Similarly, AI tools can be engaged and integrated into your IT infrastructure in the same manner as e-discovery tools. The next one is confidentiality of information, as well as communications with a client. That's 1.4 and 1.6. 5.3 is responsibilities regarding non-lawyer assistance. So making sure that AI vendors are properly supervised, right? An AI vendor counts as a non-lawyer assistant. We're essentially, as lawyers, responsible for our assistants' actions, right? When they pertain to the work that we're putting in front of the work product we're putting in a public filing, or our responsibilities and communications with our clients. So just like you're responsible for your assistant and your paralegal, you're responsible for what the output of the AI tool and how you use it. And so if you think of the AI tool as an assistant and use it as an assistant, that could really, bring home the idea that you're still responsible for that at the end of the day. The ABA Business Law today put out an article that stresses that competence means knowing where your data goes. The ABA also put out another report that warns that even AI note takers can capture client confidences. So that brings up another issue, which is AI note takers that automatically pop up when you join a Zoom or a Teams. And I've always been wary of them. And so now what I do and I recommend lawyers do is, your client joins a call and there's a AI tool that automatically is there, immediately kick it out of the meeting. Because you don't know, and you know whether that tool is really using the data to train the model. You don't know if the information is going to end up in the hands of a third party. There's always that risk, unless if you have properly engaged the tool. And again, it's a closed system, and it is all of the safeguards have been built into that process. But your standard kind of commercially available tool out there that just joins a Zoom for you automatically and starts taking notes and summarizing what everyone is saying, there is risk in that. And so I would heed that warning to maintain the confidentiality by not relying on them. Which in some cases, this is a challenge for some clients. They think that, an AI note taker can result in efficiencies. We Now you have someone who's taking notes for you, that's very accurate, that's tested. Um, you lose that because now you're relying on your own note taking as a lawyer. But that's what we're paid to do. We're good at taking notes and ensuring that we don't miss the details. But sometimes, depending on the circumstances, you may need to have someone else, an actual human, with you to help you take notes and maintain the information confidentially. But every circumstance obviously is different. But AI note takers can certainly result in some risk to be concerned about. Um, and this is the uh, formal opinion, ABA formal opinion 512 that was issued July 29, 2024. And it really comes down to three things. They say lawyers remain fully accountable for all work product, regardless of how it is generated. The existing rules of professional conduct are sufficient to govern AI use in the legal practice. And AI is here to stay. It is not going away. So we all better jump on board and understand it as lawyers. Obviously, they delved into a lot more, but if you were to summarize, the takeaways, I think these are the three key takeaways from that opinion. All right, attorney-client privilege and work product at a glance. Just a quick summary. It's review for all of you, I'm sure, but just so we're setting the stage for the next discussion here. Privilege protects confidential communications for the purpose of legal advice between an attorney and a client. And so it protects communications and the contents of those communications. Including if the communication is, between non-lawyers at a company, for example, and forwarding a lawyer's communication. That's still attorney-client communication now being discussed internally between people discussing that legal advice. That could also extend to, to that communication as well. We're still talking about communications that are privileged because they pertain to either requesting legal advice, providing legal advice, gathering information for the purpose of providing or requesting legal advice. Anything within that scope would be covered by the privilege. But the privilege is then waived when the information or the contents of those communications are shared with a third party. The work product is obviously a little different because work product doesn't cover communications. Although communications may contain work product, and they usually do if they're substantive, the work product doctrine protects attorney impressions, thoughts, strategies, opinions, notes, things that the lawyer takes that they may never share with their client because it's their own process and their own thoughts and notes. These are things that don't necessarily belong to a client in a client file if you never shared them and they're not part of a communication. They are yours as an attorney. They are your attorney work product, and you're the one that holds the privilege as the lawyer to protect that information on behalf of your client if it contains client information and client confidences. But it's also you're the holder of the privilege, as opposed to the attorney-client communications where the client is the holder of the privilege and only the client can waive those communications. The work product, if it contains client information as well, the client is the holder of the privilege, and you would not be able to waive attorney work product protection if the attorney work product contains client confidences and information that the client is the holder of. There's certainly that overlap here. All right. So another rule to mention and discuss is the Evidence Code 954 regarding the scope of the privilege. A client has the privilege to refuse to disclose and to prevent another from disclosing a confidential communication between a client and a lawyer. A confidential communication means one that is made in the course of the relationship and in confidence, meaning there has to be an attorney-client relationship between the two. or in a potential relationship, like if it's a prospective client and they are reaching out for potential legal advice to evaluate whether to hire the lawyer or not, that's still a protected communication. As long as it's maintained confidentially in a confidential setting, there's an expectation of privacy in that communication, and there isn't a third party that is outside of that relationship. The disclosure to a third party, like an AI vendor, can defeat the confidence requirement. And next is the California Work Product Doctrine under CCP 2018.030 that talks about absolute protection versus qualified protection. Qualified protection for attorney work product sometimes can involve your notes about communications with third parties. For example, if you interview witnesses, there are courts that find that there's a qualified work product a protection for interview notes with third parties if those notes would reveal your thoughts and strategies and analysis of your client's position in a case based on what a third party witness is telling you, even though you don't have an actual attorney-client relationship with that third party. The absolute protection would cover writings containing attorney impressions, conclusions, opinions, or legal research, and so on. Again, disclosure to a non-agent waives the protection and allows the opposing counsel to seek discovery of AI chat records. And there's been a couple of key cases that we should talk about. The first is Trembly versus OpenAI, decided by the Northern District of California in August of 2024. There, the court held that attorney crafted prompts to Gen AI like ChatGPT constitute opinion work product rather than fact work product, and that's a key distinction. And as a result, prompts may be discoverable if they are fact work product versus opinion. Prompts here, in this case, the prompts contain counsel's mental impression and strategic thinking about how to interrogate an AI systems in anticipation of litigation, making them virtually undiscoverable unless opposing parties can show that the attorney's mental impressions are actually at issue in the case and demonstrate a compelling need for the materials. So how do you demonstrate a compelling need for the materials? I guess it depends on every case and whether that is called into question. Which brings me back to the hallucination cases where a lawyer creates a prompt and based on the prompt a bunch of fake citations are generated and then they use that. Well, maybe the prompt at that point and whatever the lawyer told the Gen AI tool is an issue, right? So they may end up having to potentially disclose to the court what the prompt was that led to all of these fake citations being generated. So that's one example of where it might be an issue where, your work product can be discoverable if it becomes an issue. The Trembly case has been cited and followed, it's gonna lead to more cases that would cite to it, but it's probably the first place that I would start in analyzing this issue if you are facing it in litigation. Another court that has looked at this is Concord versus Music versus Anthropic, and it's a case decided in May of this year, 2025. And in that case, court found that certain prompts, settings, and outputs from Claude AI were protected, rejecting the argument that they were automatically discoverable. The court in this case emphasized that these materials were generated during the investigative process by the lawyer, and therefore they qualified for attorney work product protection. The protection can be waived when a party relies on that material in their pleadings or in their motions. So that's the key, that the prompts, the settings, the outputs from a Gen AI tool, if you rely on them in your pleadings or motions, then they can potentially be discoverable. So how do you not rely on them? right? Well, that's where use the AI, Gen AI as an assistant, truly as an assistant. It's your first, it can be a first run, but you're still responsible for critically thinking through the arguments, the summary, verifying the facts, verifying the citations, and everything before you put it in front of the court so that you never put your interaction with an AI tool at issue. So that's one way to do it to put a barrier. Um, the implied waiver of attorney-client privilege and attorney work product occurs when a party's conduct, such as using an AI platform, places privileged information at issue or makes it relevant to a claim or defense. For example, if an attorney uses an AI tool to process or analyze privileged communications, um, for example, you have a bunch of communications between you and a client, and you put those communications into the tool, and the tool's design or operation involves sharing the data with the third parties. So maybe that AI tool is sharing data with third parties, or now the information is out in the ether, and it is uh, it's now in the hands of a third party. It could be construed as a voluntary disclosure, thereby waiving the privilege. And that herein lies the danger of using Gen AI for summarizing client communications. Maybe one way to do it is to redact all of the information before you put it in. So that requires tedious manual work potentially to redact everything before you put the information into the Gen AI tool and before you ask for the summary. Courts have, and there's been courts, obviously before the advent of AI that have addressed this implied waiver issue, but generally courts have emphasized that fairness principles guide the application of the implied waiver, particularly when the privilege is used as both a shield and a sword, or when the opposing party is denied access to information that is vital to their case. So there's going to be general fairness guidelines that are addressed here as we deal with this new AI era. Before I talk about the CCPA, I want to mention that work product often includes notes and drafts. If you upload them to an AI tool that stores data off-site, then potentially you've disclosed them. And so where the data is stored is very important in understanding what tool you're engaging. If you're a law firm, just like you're engaging an e-discovery, vendor, for example, know where your data is stored, right? And know who has access to your data. Engage in the proper vetting of that vendor. Bring that same expertise and experience you've developed in engaging and onboarding an e-discovery vendor and apply it to an AI tool. It's the same thing. It's just another vendor who's going to have access to potentially confidential and sensitive information. So you have an obligation to properly vet that vendor to ensure that they are securing the data, maintaining it safely. They're not disclosing it to the third parties, and they agree to comply contractually with these obligations. But for AI tools, one of the best ways is to make sure that you're in a closed system where the data isn't going to a third party. The CCPA is just another complicating layer, right? So there's ethical standards, there's ethical rules and rules of professional responsibility. Then there's the CCPA. It doesn't apply to every lawyer. It applies probably to all of the large law firms out there, and any law firm that meets the threshold of being a business operating in California, that operates in California, that collects information about people that are California residents. So if you meet the threshold, then this consumer privacy law applies to you. So why do I bring it up in this context? It's that a law firm that had a person, any attorney at any level share information with a client's information with a Gen AI tool, and let's say that information happens to be sensitive data, you may have a potential CCPA problem on your hand. Um, and that's because the CCPA requires a covered business to maintain appropriate security measures to ensure that there is no unauthorized disclosure or access to certain sensitive data. Social security numbers, medical information, things along those lines, and they're defined in the law as to what actually is covered in this part of the statute. So it's certain types of sensitive data. If the documents that are being uploaded contain that information, it potentially could be a data breach, right? Not just under the CCPA, but under other data breach laws. But that's very concerning, especially because there is a private right of action under the CCPA, and that can subject you to liability. And the liability doesn't require proof of harm, although there could be major and significant harm from disclosure of a client's sensitive and confidential information. But even if there is no actual harm that is provable, under the CCPA, there are statutory damages that are recoverable regardless of harm. So that's why this is significant. If you're disclosing information to a Gen AI tool, that you certainly have to worry about the ethical obligations and potential disclosure of information in violation of those ethical duties. But now you may have a data breach on your hands. So that's the reality. When you hit enter, the reality on any kind of AI tool and submit your prompt, AI systems often log the text for quality control. No training modes still cache data, and vendors can be subpoenaed. There's rarely a real deletion right. So what you type today can reappear tomorrow. Clients ask, can't we tell the chatbot not to remember? And I'd say, sure. And tell your toddler not to repeat what you said in the car. Good luck with that. It's really important that technology, that reality about this technology, that whatever you type in, it's there, right? Your ability to remove it after you've hit submit is virtually none at this point. Now we may get to a different point down the road where someone addresses that issue and creates safeguards, and now you may have the ability to remove information from the hands of the vendor. But once you've submitted to the vendor, it's there. It's in their hands. The waiver of the privilege occurs upon disclosure. Work product loses protection if shared with a non-agent. There is no common interest or agency relationship with the AI provider, so you can't really claim protection of the information under that issue. Even if off, data may be cached or for debugging, like I mentioned, and the third-party vendors can potentially access or be subpoenaed for records. It's really important to understand that you may not have any meaningful right to deletion or control of the information once it has been submitted. There are a lot of common uses of AI chat tools by lawyers. This includes drafting memos, motions, discovery requests, like I mentioned earlier, summarizing depositions or client emails, brainstorming legal arguments or case strategy, checking citation formats or tone polishing, putting in a case saying, hey, can you look up, can you summarize the case? Putting in a case and saying, do I have the right citation for this? Or find other cases like this, right? And beyond just simply using the other standard research methods that you have through Lexis or Westlaw or other tools that are out there. So there are a number of ways that AI tools can be used by lawyers. Now we have to make sure as lawyers that we are using AI tools responsibly. Realistic examples of confidential data that lawyers may input include client identifiers and case names, right? So make sure that you're removing identifiers and case names. I even try to ensure that I'm only using my personal email with any chat tool, and I'm not connecting anything that I put with my firm. And that's just to create a separation. So anything I put in there, I say, I'm a privacy lawyer at a big law firm, and I'm going to do XYZ, and I'm thinking of writing a message to so and so, without naming them, of course, to someone who is in this type of business. Give me a a few starting paragraphs, or give me a couple of points that I can start and I can work from. So that's just an example of making sure that I'm not using client identifiers, a case name, so that it's not linkable back to a specific client or particular matter that you're working on. Um, uh, Factual summaries of harassment or termination allegations. You put in your witness interviews from a harassment investigation or workplace investigation, and you put it into the AI tool and ask for a summary. Prepare the first report. Here are all 15 witnesses I interviewed. Prepare the report. What should be my findings based on what everyone said. um, that is going to be ripe with potentially disclosing privileged information or confidential information that is sensitive in nature, especially based on these kinds of allegations. Draft settlement agreements with dollar figures. Well, a lot of these agreements are going to have confidentiality obligations, right? Not to mention that, if there are changes and things that are going back and forth and with the opposing party, um, a disclosure of these drafts, including work product drafts that haven't been shared with anybody, putting those kind of drafts into the AI tool can risk having the information be no longer protected. Internal work product is another example. Litigation strategy notes that your client doesn't see, but putting that into an AI tool and asking for a summary, asking to organize it, asking to make sense of it, for example, that could be risky, unless, of course, you implement the right safeguards. And I've already talked about some of those safeguards, like ensuring that the data isn't going somewhere else, that it's a closed system, and the model isn't being trained using your information or your client's information. Another example here is a client email text that is quoted verbatim for tone suggestions. Well, if it's a verbatim quote, it can be found. It can be identified later, and tracked to whoever said it. So that's just another risk that is out there. There is certainly practical exposure when using AI tools. The exposure can be to subpoena or discovery risk. Opposing counsel may request AI chat logs as evidence of waiver or work product disclosure. There's a risk of erosion of the privilege. Once disclosed, the privilege cannot be clawed back. Work product loss. Conversations may be discoverable as non-privileged materials. There's also the client trust impact, reputational and malpractice consequences, which could be quite devastating to your practice. In fact, I may think of this one as the probably the most important one. We all thrive for client trust. This is a very trust based industry. You start with having trust with your clients. If you don't have that, you don't have anything. Frankly. So I would actually put that at the top as the worst possible scenario. You lose the trust of your client. Other things that can happen are bad, but it's not as bad as you've lost the trust, right? You lose the trust, then like, what are you doing, right, as a lawyer? So those are all significant risks to address. How AI undermines work product protection includes uploading drafts. I've seen a question here about uploading drafts or legal strategy that can convert them into shared documents. Courts treat disclosure to third parties, tech providers as an intentional waiver, and this is becoming more of an issue. the protection under the code evaporates when confidentiality is not maintained. The responsible AI use in law practice includes addressing these particular safeguards that I have here on this slide. But first, and probably one of the more important ones, is to use an enterprise licensed AI tool. For example, ChatGPT Team, Microsoft Copilot with data isolation, and as opposed to having an individual, premium version. Even that, if you're a law firm, I wouldn't put any confidential client information in it, because there's always the risk of disclosure. That is a third party you're interacting with. They're not your agent. There's no common interest. There's no you're not signing a contract, hiring them as your service provider and vendor, like an e-discovery vendor. They're just an AI tool, an AI provider that you're signing up according to whatever terms of use they have, or end user license agreement that they have. So if you invest in the enterprise version of all of these tools, that's really one of the best way to maintain the privilege and to maintain confidentiality. Obviously, never input client identifiers or facts. Treat AI output as non-confidential drafts, right? And because they are non-confidential, if it's the output of an AI tool, it is because it could potentially be discoverable. Review all the results for accuracy and hallucinations, and ensure that you're not putting anything out there outside of your firm that hasn't been reviewed by a human. The technology can help us do our job, faster, better, more, cheaper. But it is not a replacement for the lawyer exercising their own due diligence, and their own duty of competence, their duty to supervise more junior attorneys and paralegals and assistants, to ensure that you're not putting out work product that is full of even a single not just talking about full of hallucinations. Even one hallucination is bad enough, right? I think my audio cut out there for a second, so I am back. So it is the duty of the lawyer to ensure that everything that you put out that is a public filing, anything that leaves your firm, has been reviewed for accuracy, has been checked. Before the advent of AI, it was always your duty to check and cite. That's why the best practice whenever we file a brief is there's always someone who's gonna double check these cases to ensure that they're still good law, right? When you're citing a case, you want to make sure you're citing it for the right proposition, and you're not just putting a citation in a brief in front of a judge for something that the case doesn't stand for, right? Or putting in the wrong citations. So there's always someone that had to have been checking these, right? Now you have some technology that can help check those, in a more efficient manner, but it's still your duty to ensure that everything has been checked. And every day we are hearing more and more about these hallucinations in legal briefs. And they really create some significant risk. But for purposes of today's discussion, the risk is not just in creating false, fake case citations, but in disclosing confidential information about clients as well as work product of the attorney. The last issue here, the last recommended practice for responsible AI use is to disclose AI use to clients when appropriate. There's always been a debate, among lawyers, ever since AI came on the scene, that do you really have to disclose to your clients, that you're using AI? they don't necessarily, you don't have to tell them every little detail of how you do your job of every program hey, by the way, we use Microsoft and we use this and we use that. You've never had that level of specific obligation to disclose the specific tools to them, right? You can go and engage an e-discovery vendor to engage in forensics and e-discovery. Did you have to necessarily disclose to a client that, hey, by the way, when you work with us, your data is going to be put into relativity, and we have relativity with this vendor or that provider. I'm not sure what the answer is, because it really depends on where the client is, depends on the ethical obligations, your contract with the particular client. But there's the law, and there's the what is actually required, and then there's the best practice. Best practice is always transparency. Clients appreciate it. It's it's important that they know that they can trust you. It's one way to establish trust, that hey, I'm using AI tools to do my job in a more efficient manner, so I can serve you better. Do you have any concerns? If you have any concerns, let's run through them. Hey, we've made sure that the AI tools that we are using are in a closed system. The data isn't going somewhere else. So all of these things can be addressed upfront with your clients. The California State Bar has a standing committee on professional responsibility and conduct, and they've come up with guidance for use of Gen AI, and it covers a lot of different things. And I just wanted to highlight some of the key issues, that some of the key guidance that they put in that document. It's a very short document. I recommend that all of you read it, because it covers how the existing rules apply in the context of using Gen AI. But some of the key things are, you should review the terms of use of your Gen AI apps. As lawyers, unless if you're in that in that kind of field that involves reading and writing terms of use and contracts, if you're a very contract oriented lawyer, when it comes to our own personal uses of apps, who here, if this was a live audience and I say, who here has ever read the the end user agreement for pick an app on your iPhone? Have you read it? I guarantee no one will ever raise their hand, right? So this should be different for lawyers. So the idea is we need to hold ourselves to a higher standard, and we should actually review the terms of use. If you're at a larger firm and you're engaging an AI tool on an enterprise level, then obviously you're going to have a team of people whose job is, or part of their job is going to be vetting that vendor and reading those terms and understanding them, and understanding how, what are the limitations, what are the guardrails, what are the risks, have they addressed security, data security, have they addressed where the data is being stored, who has access to the data. Training the model is probably one of the most important issues here. So those are all things that you should address at when you are reviewing the terms of use of your Gen AI apps. Number two, from this guidance, is an emphasis on consulting with technical experts. And I've mentioned this a couple of times already, but I'll re-emphasize it here. The State Bar Committee recommends that that you engage experts if you don't know, and if you don't understand these tools, that you actually engage experts. The experts can be another lawyer that's actually dealt with this, an AI expert, an AI lawyer. The expert could be a technical consultant. There are many technical consultants out there that work with law firms to help them with AI governance and dealing with AI tools, how to onboard them properly, how to vet them properly. There are technical experts out there. You don't have the, if you are, pick any kind of you're a personal injury lawyer, do you even have the time to become your own expert on the tool, right? You should consult an expert to advise you on how to implement and how to use this technology properly. And there are consultants out there that focus on this industry. You can also utilize a particular vendor that you are, seeking to or to implement. If it, like I said earlier, you can get information directly from ChatGPT about how best to use it. What are the limitations? It'll answer some of the questions. Now, can you trust the answers all the time? They could be hallucinations, so you still need to get some independent review and advice on that. The third recommendation, again, among many, I think they have like over 10 different things they addressed. I picked the 4 that are most relevant for our discussion today. Never input confidential information without proper confidentiality and security protections. So what are those confidentiality and security protections? That's going to depend on your client's expectations, the type of information at issue, the type of technology that you're using, all these factors. And then the last one is you got to properly supervise junior attorneys. And that really goes without saying, because the last thing, if you're a partner and you have an associate working for you, the last thing you'd want is for a brief to get filed that you didn't lay eyes on properly, you didn't test, and that you didn't verify that your junior associate who prepared it had actually vetted every case, right? Having proper training is another way for doing this. So if you're not a solo practitioner and you have lawyers working under you and paralegals, ensuring that they receive the appropriate training. Now, how do you find this kind of training? Who provides it? Again, go back to the technical expert. There are consulting firms out there that will provide training for your team on how to properly use AI tools and how to understand it. This includes having a policy. So if you don't have a written policy for your team that they can read, they can reference, that explains to them what the rules are, what the guardrails are, that's the first step: a policy, training, and then as well as proper supervision to make sure that you've asked the questions every time, that nothing leaves the door without ever being checked for hallucinations, as well as to ensure that you haven't disclosed confidential information. Excuse me. Privileged means private. AI isn't. Public AI chats means disclosure to a third party. Some of this is a repetition. Use AI only under vetted control systems. Be the lawyer who understands both the law and technology. That'll give you an edge over others who either understand one or the other. That would be kind of the takeaways. But there are a lot of questions here. I'm going to get to the questions. Legislators are discussing safe harbors for lawyer-directed AI and treating AI vendors as agents when under confidential contracts. Data privacy advocates are also out there trying to address these issues. They want default deletion and subpoena notice rules, but that could be years before the legislature does anything in that regard. So until then, we got to stay cautious and keep clients from sending midnight ChatGPT queries. AI is really an amazing assistant, but a terrible confidant. So treat it like a summer associate. Helpful, fast, but don't trust it unsupervised. If you remember nothing, privilege means private and AI isn't. Now let me go over some of the questions that are here in the next 7 minutes that we have. First question was, no work product protection even with disguised names. Well, disguised names will disguise the client, but it's still your input as an attorney into this. So you've put your impressions, your thoughts, your analysis into the prompt itself, into the AI tool. You've interacted with it. Even if you're interacting with it without mentioning client identifiers, the work product protection may be gone with respect to the interactions. in the event that it's at issue, right? So we've talked about the Tremblay case where the court said it's virtually undiscoverable. Well, yeah, virtually undiscoverable, but what if now the prompt that and what you put in there is at issue, because it could be in some cases, and which is a risk that I wouldn't take with my own work product, even if I'm not including any client identifiers. Next question, how can one make confidential uploads to ChatGPT and Claude AI? I have the $20 subscription to both. The answer is you need to have the enterprise version. So it needs to be a closed system, enterprise version, closed system only. The $20 subscription premium version, yeah, that's great. That's helpful. It means maybe they're not using the information to train their model. There are some additional protections, but at this point, when it comes to attorney work product and attorney client privilege, I still wouldn't trust it at this point. Do you see waiver problems if you publicly upload documents already filed in a case and request responses to those documents? If the information is already publicly available and you're asking ChatGPT to summarize a publicly available document, you're not disclosing attorney-client privilege information. Then the only issue is back to attorney work product, like I talked about earlier. There's always that risk that it could potentially be discoverable if it becomes an issue. There's fairness standards, fairness considerations, things that may come up, right, in those cases that put your work product at issue. So that's the risk, and if I don't think it's worth taking. Next question: does the Plus membership ChatGPT notice that OpenAI doesn't use their work space data to train its models, provide adequate privacy for document uploads? No. It means that they're not using the data to train the model. But does this mean that you can, give it as a third party your confidential client information without breaking the privilege? No, I think it can still break the privilege by uploading information. Is an AI like an assistant? Well, exactly so. Yes. So my communications with an assistant are protected. It's an assistant, but it's a third party, right? They're not they're not your employee, they're not your agent. But we say as an assistant, not in the like as an employee, as an agent, but use it as an assistant. That is the best use of a Gen AI tool. Is they're someone who can assist you to get started, but not the one who will do the work for you, who will just get you the final. And here's something you can actually rely on at the end of the day. It's a place to get started, to facilitate, to help you on the journey, in the process of getting to where you need to be. But that's why I say use them as an assistant. But they're still a third party. Okay. Says, question for later. If copying private material to ChatGPT can create privilege waiver problems, then what about firms with a long-term practice of automatically transferring client files to a commercial cloud service for backup? I don't think that's creates a privilege issue. That's when you have a server, whether it's in the cloud or not, when you engage cloud-based services to store data, you're engaging them as a vendor, just like an e-discovery vendor, that I mentioned earlier. Same kind of vetting that you would engage in to ensure proper protocols, cybersecurity protocols are in place to ensure that no one has access to the data. And they just become a storage facility for you. So when you hire someone to store data for you, they are in that capacity your agent in storing and maintaining the data. It's as if the data is just in your building, but now it's in someone else's building, and you've hired someone to guard it and to safeguard it. So it's different. It's not the same thing as ChatGPT and data being out there with a third party. you're not engaging ChatGPT as a data processor, for example. To use CCPA terms, they're not a service provider. A service provider under the CCPA or a data processor under GDPR or other state privacy laws that use the processor terminology is a vendor that is agreeing contractually to not use the data for purposes outside the scope of the services they're providing, to not sell the data, to not share the data, to cooperate with your obligations related to privacy law, and a bunch of other restrictions. You're not doing that with the $20 subscription to ChatGPT. But you are doing that with a vendor that is a cloud-based, hosting service to host your data somewhere. Those you would have a DPA with them. You would have that kind of a data protection agreement with that kind of vendor. So these are two different things. We are running out of time, and there are a lot of questions. So I'm going to kind of scroll through and get to at least one or two final questions. Here's a question. As AI becomes baked into apps like MS Word, an attorney forgets to disable it. It is also baked into your phone and newer computers. Then is now your computer fair game? These things happen with updates, so it can be challenging to keep up. Yeah, I've seen that too, but I don't, AI is getting baked into existing apps. It doesn't change the fact that those apps that you're using, like Word and Outlook and other things, they're still engaged through a service provider type of model, and so there's still segregation of data. There's still protection of data, no disclosure. It's still like hiring a vendor. So all of that technology that is in use within that same closed environment and system doesn't necessarily mean that you're giving data to a third party. As long as it's still a closed system, enterprise type application, I think you'll be fine. All right. Wow, there are a lot of questions. All right. I'm going to have to get one final question. How is CoCounsel safer? Because CoCounsel would be engaged as an enterprise type of system. It's a closed system as well in terms of what data it references. So if you're doing research using CoCounsel, it's been trained on all the legal research repositories out there, and it's limited to those repositories that you link it to. So it's not going to create new things. You still have to review it, but it's still a closed system. Unless it's still important to not include confidential client information but if you've engaged that tool at an enterprise level in a closed system, then you have at least mitigated the risk that you are disclosing client information when you're interacting with it. I appreciate that there's a lot of questions, and I'm sorry that I was unable to get to all of them. There are, I've certainly hit a button here with the number of questions that have come in. So it's an important topic. I would love to continue the conversation going, but thank you all for attending. I'm happy to chat with you at any point as well. Feel free to reach out. And I just as a colleague in the bar, I'm happy to share knowledge and to continue to help any lawyer with this issue. Thank you all, and have a good day.